Kishan Bhatt, and we're here for episode 1 of Learning HR. And I'm very glad that all of you have joined us today to learn a bit more about employment law and the updates for 2018. And also, we're also going to give an overview on performance improvement plans and recruitment tips, which will be given by Lucy. I'm joined by Lucy here. Thank you, Lucy, from Absolute HR for joining us today.
Thank you, Kishan, for having me.
No, not to worry at all. And we're quite excited to hear a bit more about recruitment tips and how you should go about recruiting. So let's start. Let's look at what we're looking at today. So just a brief overview of what Learning HR is all about. It's going to be a platform for HR consultants, HR directors, HR managers, and advisors for them to learn a bit more about employment law and the most up-to-date updates every month. And also we're giving regular HR tips from leading experts in the field, and it gives you an opportunity to give me questions about employment law generally, and also any kind of further discussions you may want to have after. So a bit about us. We're a Fusion Law's full-service business law firm, and we provide legal consultancy services in employment law, commercial, corporate, and litigation work through an authorised, regulated legal practice. And my background is I was a trained barrister, and I'm now currently qualified solicitor, and my bread and butter area is employment law, and that's why we're here today. And a bit, I guess, Lucy, perhaps you can give an introduction about yourself and what Absolute HR does.
Yeah, absolutely. So Absolute HR is a specialist recruiter focusing on the HR profession. So really we do the full spectrum. So that's anything from entry level to exec across all your specialisms. So HR is quite a personal function within the business. You want somebody who's going to really represent not only your organisation but your people. And when it comes to the more complex roles, so sort of at reward level, then that's where we can really add value, sort of your L&D specialists or your ER specialists. With the sort of generalist roles, again, we can really help you narrow down and find the people who are going to make the biggest waves and add the most value within the organisation. Me, myself, I'm from a HR background, so I did my bachelor's degree in HR, and just last December finished my master's degree, so I'm now level 7 CIPD accredited, and just recently decided to make the move into recruitment, which is why I'm here today.
Sounds exciting. Thank you, Lucy. It's really good to have you here. Okay, so let's look at what we will be learning today. So the first thing we'll be looking at is the impact of GDPR. I know it's the dreaded word, but it is very important to see the changes in this area and how it's impacting employment law and HR. And then you can see the various things that we're looking at. We'll be looking at whether or not you can discriminate against someone because of a particular philosophical belief. Recent tribunal case that went to tribunal. The third thing we're looking at is whether or not voluntary overtime qualifies as normal remuneration when we calculate holiday pay. It's always been a topical area about whether or not calculating holiday pay takes into account overtime or voluntary overtime. It's always a difficult one for HR managers to calculate, but we will be giving you the verdict on that. Discrimination arising from disability, I think that's quite an important area, and I think it's one that a lot of people tend to forget about, so we'll be revisiting that in the light of new case law. The fifth one's an interesting one. We're going to have a little discussion about whether or not it's fair to dismiss a man for having a man bun. This is a recent sort of British Airways case that's going on, and we'll be looking at what our views are on that. The sixth one is when do you have to really postpone a disciplinary hearing? There's various circumstances in which you should do so. There's those that are mandatory and those that are not so mandatory, but we'll be looking into the ins and outs of that. I'll be giving the tips of the month on performance improvement plans and how to make the most out of them. And Lucy will be looking at how to recruit the best staff for your business, looking at assessing requirements, skills, level of seniority, employment background. We're also looking at the cultural fit and how to manage that process. So So the impact of GDPR on employment law. So this is obviously quite a topical area at the moment, and I've broken down to the key sections, which I think are kind of highlight why GDPR is so important in HR and employment law generally. Naturally, you're going to be storing a lot of employment data. You're going to be storing payroll information, that's personal bank information. You're going to be storing employment contracts, CVs. So inevitably, you're going to be holding personal data of employees. So what do you do in that situation? Well, the first thing is making sure that you do some sort of a GDPR audit or gap analysis to make sure that you fulfilled the requirements under the new legislation. And one of the key requirements is to make sure that you meet efficient and reasonable technical and organizational measures. And at least you've taken some steps to do that. And when looking at your IT processes and procedures, it's important that you store away and file very sensitive personal data, such as payroll information and financial information, and even medical information, particularly, in a very safe place, which is has a lock-in key. It's not kept, out in the open where someone can have easy access to it, but it's locked away securely if you're having a paper file. There is obviously a greater emphasis now on moving away from paper files, but to also store such data on computers. But if you do so, it's important to make sure that you have the latest antivirus available. You have something that we call two-factor authentication. These are all good recommendations to make sure that the data you do hold in your laptops, in your computers, are held in the most secure way. But also spreadsheets, making sure that spreadsheets are password protected. So there's various things that you just need to be aware of when you're trying to protect employee data. And a lot of people do forget about these things. The second thing to look at is employment contracts. Now, what I do recommend is to check your contracts of employment to see whether you have previously requested consent to process personal data. There's usually a personal data clause or data protection clause, and it's important to revisit them and revise those clauses in light of the new law. Previous consents are likely to be now deemed to be invalid and non-compliant, because it is unlikely that these consents were given freely, as they usually kind of have this an imbalance of power between employee and employer. So because the new law has an emphasis on giving consent freely, it's important that that's done separately now. So we would recommend a separate letter, a variation of contracts through the best way around it, or we draft a new clause to be inserted into new and upcoming contracts. So that's employment contract. What about recruitment and selection? Well, it's quite a hot topic, but the key thing to be aware of is that you should be having a solid GDPR compliant privacy notice. And that privacy notice should be sent to all the applicants, explaining how you will use their data and how you will store their personal data through the whole application process. And if you propose to transfer their data to third parties or to other countries, you need to also include this information and explain the safeguards that you currently have in place. And those safeguards are the technical and organizational measures that I just spoke about. So in order to comply with those new stringent sort of GDPR requirements. Any applicant should also be made aware in clear terms the circumstances in which you exercise your right to access that data, their right to request deletion, which we'll be going through in a moment. And if you're using the services of a recruitment agency, then a contract should be in place between you, the hirer, and the agency, explaining how a particular applicant's personal data will be processed. So it is a very interesting area, and I think that it's one that's obviously going to grow in terms of case law. GDPR is quite new. There's not many cases out there at the moment that are deliberating on it, but it's going to be an area which is going to evolve. Now, how long should you hold data for? Now, the golden rule for holding payroll information, for example, when you're processing it for HMRC, is between 6 to 7 years, because of course HMRC may require that information for that period of time. But the answer to this question is pretty much a subjective one. You should only really be holding personal data of an employee for as long as you need to. Now, if the employee's left their employment and you have information about their disciplinary record, then it may be relevant for 6 months to a year, but after they've left and after that period of time, it's unlikely that you'll need to have that information held still somewhere, either in a paper file or electronic format. So I think it's important to use and exercise your judgment on a case-by-case basis, and actually look at the personal data and break it down into different areas and different sort of categories, so you can then make a judgment and determine whether or not you should be holding that data for a longer period of time or a shorter period of time. So it is a subjective one, but one that should be looked at quite carefully. When we're looking at consents for medical and occupational health records, obviously this is what we call sensitive personal data. So because it's sensitive personal data, you should be getting specific consent from the employee before obtaining a medical or occupational report. If you are processing this type of personal data, then you must not only provide the purpose and the lawful basis for why you're processing it, but also you've got to provide an additional condition for processing it. And where consent is obtained, remember, an employee should be made aware of how that consent can also be withdrawn. So again, having a properly drafted privacy notice and a properly drafted privacy policy, which can be used internally by your staff, is very important when they're handling an employee's sensitive personal data. And again, it comes down to training. So it's one of the emphasis of GDPR is to make sure you give the best staff training you can. And so that in-house staff training, I think, is quite essential for everyone to know what the new requirements are. Now, I've seen a lot of employees have come to me to help them against their employer, and I've acted for a lot of them out there. And a lot of employers have also come to me when they've received these requests from employees on the other side. Now, what is happening at the moment is that there's a lot of tactical use of subject access requests made by employees where they want, before a potential tribunal claim or as soon as they've left for any reason, they are asking for all their data to be given to them. Now, it has to be a reasonable request, but it has to be one that the employer has to also comply with. So you just have to be aware of how to deal with these requests in a proper way. And it is sometimes a case of making sure that the type of requests that are being made are quite specific. And if they're not specific and they're very vague, so for example, if they're asking for any kind of data that you hold of them, then it's important to go back to them with a letter to explain, actually, I do need just my information about my disciplinary record, or I just want my information about my sickness absence record. And you will be under an obligation to give that to them. And if you don't do that within a very short time frame, then you could be in breach of data protection laws. So I think it's important to make sure you know your obligations under the subject access requests. In addition to that, there's been a sort of a tactical use of data deletion, data rectification, and right to object from employees in terms of personal data that's held of them from employers. And usually this comes down to references. So when there's a request for a reference being made by a new employer, on that in breach of, an employee may not have wanted you to pass any kind of personal data about them to a new employer. Miscommunication or misuse of of an opinion of a particular employee. Usually the norm is that you would give a factual reference, but also employees have a right to make sure that that factual information is correct. Quite often there's an obligation on employers may want to disclose a disciplinary record or a sickness absence record of a particular employee when submitting a reference. But what employees have the right to do is have a right to object to you from sending that kind of reference or sending that kind of personal data across to a new employer, or have a right for you to amend that reference by rectifying that data, and they can do so by drafting a formal request in writing, by writing a letter to you. So what you need to be aware of is that employees do have a right to do that, and as employers, you need to be aware of that right and to make sure that you respond carefully under each situation. Where you where employees have a bit more discretion over this area is when they are regulated. So if there's a regulatory body which they have to sort of adhere to, they may want to disclose their disciplinary records. So this was kind of the key area that I wanted to speak to you about today, was the update of GDPR and how it impacts on employment law. Turning to this question about, this is an interesting question, isn't it, about can you discriminate against someone who has a particular philosophical belief, the key word being particular. The answer is no, it's difficult. In the case of Gray and Mulberry, the Employment Appeals Tribunal held that a belief in the sanctity of copyright law, which was apparently this philosophical belief, wasn't sufficient to protect that employee under the Equality Act 2010. So I mean, this employee brought this claim against an employer saying that they had a belief in the sanctity of copyright law and thought that because of that belief they were discriminated against. Well, that the EAT said that it can't be discrimination. So even if it was a protected belief, and even if it was considered to be a protected belief under the Equality Act, the Employment Appeals Tribunal held that even if it was an indirect discrimination claim, it wouldn't succeed because the claimant was the only person known to hold such a belief. It's not a very wide belief to have belief in the sanctity of copyright law. It's very obscure, isn't it? So
unusual choice of a philosophical standpoint.
Yeah, exactly, quite unusual. So unless you have a belief that's quite common across the board, then possibly there may be a discrimination claim, but this is very obscure. So as a result, there could be no group disadvantage, and therefore couldn't be indirect discrimination claim. It'll be interesting, and I don't know if there's any case law out there, but I'm interested to see if there's, like, for example, vegetarianism or veganism, which is becoming so common now.
I wouldn't be surprised if we saw something crop up.
Yeah.
I suppose it would be easier to get behind, someone feeling discriminated against, veganism.
Yeah, exactly.
Rather than the sanctity of copyright law.
Yeah, exactly,
so
absolutely. I think there would be. You could argue there would be a group disadvantage.
Yeah, absolutely.
Yeah. So watch this space. Now, does voluntary overtime qualify as normal remuneration when calculating holiday pay? And the answer is yes. That's what the Employment Appeals Tribunal said in the case of Flowers and others versus East of England Ambulance Trust. So the Appeals Tribunal confirmed that voluntary overtime can qualify as normal remuneration when you calculate holiday pay under the Working Time Directive. And the rule is on the condition that it is paid over a sufficient period of time and on a regular basis. So if you regularly pay someone voluntary overtime, and you do it over quite often, then that would qualify for when you calculate holiday pay. So just be aware of that law. So discrimination arising from disability. This is the case of Ali and Torasian and others. The Employment Appeals Tribunal provided a reminder that employers should always ensure that there is not a less discriminatory way of achieving a legitimate aim when they take a step to action dismissal. So in this case, the employer should have really considered whether its aims could have been achieved by permitting this Dr. Ali, who was absent on long-term sickness following a heart attack, to make reasonable adjustments to that person by getting him to return back to work on a part-time basis. And I get this question asked by a lot of employers quite regularly. When an employer is facing a difficult employee who just goes off on long-term sickness, just doesn't return back to work, there is this sort of myth out there where, what is quite common practice out there, where they hold a number of sickness absence meetings, and they will then dismiss that person eventually after some process has been followed, on the grounds of capability that the employee can't come back to work again. Well, you shouldn't do that unless you've explored all potential avenues, unless you've explored all other options available to make that employee return back, or give out options to help cope with any potential disability. And one good way around this, of course, is to make sure you send that employee to an occupational health therapist or an occupational health appointment, where you can rely on expert evidence and an expert to tell you what kind of adjustments you can make. And in this situation, offering an option to work on a part-time basis would have been a reasonable adjustment, and would have prevented this employer from any kind of discrimination. Yeah, so on the side. Another question we have to ask, and this is quite an interesting one. It's been in the news. You may have come across it. And again, we're kind of going on this theme of discrimination and the pitfalls and what to be aware of. The question is it fair to dismiss a man for having a man bun? So just give you some context. A British Airways check-in worker was dismissed after only a couple of weeks in the job because his hair did not conform to BA strict uniform standards. Mr. O'Aird wore his long hair in a bun and refused to cut it, wear it in dreadlocks, or wrap it in a turban. And these were the options I believe BA gave. And he says that these are the options that were made by BA, and he feels that he shouldn't have to do that. There's very little case law on uniforms generally, and so it's interesting to see what would happen in this situation. Lucy, what's your thoughts on this? Do you think it's fair to dismiss a man for having a man bun?
Well, it's a very interesting one, because I can see why the claimant felt discriminated against. It's his choice to wear his hair how he chooses.
Yeah.
Having said that, it is a uniform requirement, and I can see from the example you've given that they gave him some reasonable alternatives to, cutting his hair or leaving the business. So yeah, from a HR standpoint, I feel BA perhaps have acted reasonably, but from the claimant standpoint, I can see why he felt discriminated against. And it's a very difficult one, because I know that BA are quite famous for, their strict uniform requirements.
Yeah, of course.
Is it fair to let one employee have a man bun when they're perhaps imposing other restrictions on other people's uniforms? So it's a really interesting question. It'd be great to hear how it turns out.
Yeah, it would be good to hear. I don't know if this is going all the way to tribunal or not. We don't know, but it's certainly in the news out there, and it would be interesting to see what would happen. Generally speaking, if we look at the wider context of this, it would be difficult for employers to be able to justify a policy that requires, for example, women to wear skirts rather than trousers, because obviously that could be quite, I think that would be sex discrimination.
Yeah, absolutely.
But if the question is, if these standards are imposed equally, even if they are different in some ways, then the dress code will not normally amount to sex discrimination. So just a dress code doesn't normally amount to something like that. And there was a case in Safeway, which is quite a long time ago, which is quite similar to this. So I guess the question really is whether or not unconventional hairstyle for men and women amounts to some sort of less favourable treatment. And it is a subjective sort of question if the rules do amount to discrimination between both sexes, because both sexes could have unconventional hairstyles.
See, that's an interesting question. Yeah. If a female employee had, sort of bright green spiky hair, they probably would have had a similar conversation with her. So I suppose it depends what angle you're looking at it from.
Yeah, exactly. And it's probably a matter of debate, like you say, is that it could vary between sectors as well. So corporate employers such as BA may interpret this a lot more conservatively than, say, creative industries, right? So it could depend. But on the face of it, I think if BA's policy on hairstyles doesn't look as though it discriminates against men, then I don't think that there's an angle there. But apart from that, I think you just have to be aware of making sure that your staff handbook, your employee policies are quite clear on uniform, and they're checked quite thoroughly, because there are sort of very small sort of nuances and discrepancies that you just have to be very careful about.
It's interesting to see how it goes.
Yeah, definitely. Next question is, when do you have to postpone a disciplinary hearing? It happens quite often. You get employees that have got a disciplinary meeting against them, and naturally, I guess it's human instinct to expect employees to postpone hearing because of stress and anxiety, and you see it all the time. But when does postponing a rescheduled disciplinary hearing make a dismissal unfair? And I guess here what you need to look at is Section 10 of the Employment Relations Act 1999. So when you consider an employee's request to postpone a disciplinary hearing because of their non-availability of their chosen companion, for example, then employers have to be aware that if they do refuse that request, then any dismissal may be unfair, even if the refusal itself is not in breach of Section 10 of the Employment Relations Act 1999. So the answer to the question is that Section 10 provides that the employer has to agree to request to postpone if the suggested rescheduled date is within 5 working days of the original date. So you just have to be careful when you're looking at rescheduling or postponing a disciplinary hearing. So there's a recent case, of course, of Talon Engineering and Smith, where the initial disciplinary hearing was postponed due to the employee's illness and holiday, and she asked for the rescheduled date to be postponed for 2 weeks so that her union representative could accompany her, and her employer refused, and she was dismissed. And the Employment Appeals Tribunal upheld the tribunal's decision that the dismissal was procedurally unfair under the reasonableness test under the Employment Rights Act, because the employer's decision fell outside the range of reasonable responses available to it, given that it was considered to be too impatient and had acted in an over-hasty manner, which gave the employee, given that the employee had, in this case, 21 years of unblemished service, and the postponement request was only for a short period of time. So, you have to tread carefully, look at how long they've been employed for, but also I would tread carefully and make sure that you don't act too impatiently or over hasty when you're looking to postpone disciplinary hearings. I want to look at performance improvement plans, and this is sort of my tip of the month. I think performance improvement plans are a fantastic way to proactively engage your employees to get the best out of them, and also to proactively make sure that your employees are hitting targets and objectives, particularly when you feel that an employee is not in line and is sort of not achieving target. And it's useful for a number of reasons. The first reason being that a lot of employers sort of have this habit of just sort of dismissing employees because of performance. They'll enter into disciplinary hearings on the grounds of performance, which has the opposite effect, because then that discourages an employee. There's sort of a fear and anxiety built within them that they may not succeed, or they don't have what it takes to become the best that they can be. And so quite often they're not really guided in the right way because of that. So my advice would be to avoid going straight to a disciplinary hearing, to really look at performance improvement plans, have a really structured process for it, and to utilize it in the right way. The other reason for why performance improvement plans are useful is because if you do end up dismissing the employee because they're simply not performing, even after giving them a very good structured approach and a structured opportunity to improve, then you can of course rely on a performance improvement plan as evidence in the tribunal to show that you acted reasonably, you did what you could, but the employee just wasn't able to achieve targets or whatever properly. So there's a number of ways to make sure you follow a sort of a structured process. The first one is documenting performance issues. So making sure that you have like a table or a chart, and I sometimes produce these for employers where it's quite clear exactly what heading they're looking at. And you know, if a performance issue is, for example, not hitting sales targets, not producing quality written work, not communicating with clients correctly, then you have to be specific and mention those things within the plan. Then you have to develop an action plan within that. So action plan, usually the golden rule is 3 to 6 months, and then having an objective at the end of each month where you would do a peer review with that employee, and you will go through the performance improvement plan with them, and to document, when you document the performance issues, to make sure that there's some solutions around it. Talking to employees about issues, having a chat with them really helps. Going before you even put forward the performance improvement plan, before it's even implemented, perhaps you should just talk through the plan with them and see if they've got any suggestions, or if the employee's got any ideas to improve the plan which you as an employer have for them. It shows that you're engaging, you're willing to discuss things, and it avoids conflict. It avoids these kind of conflicted situations from arising. The fourth thing is highlighting employee behaviour. So where things haven't gone wrong, have gone really wrong in specific areas, so make sure that that's brought up and highlighted. So if it's, for example, not hitting sales objectives, giving reasons why that's happening. So is it because you're not tracking the progress? Is it because you're not tracking a particular deal? Is it because they haven't communicated with the potential client? You know, those kind of things, those kind of factors should be brought into the plan itself. Specific targets and goals are very useful. There's their point of having a performance improvement plan. So, for example, it could be making sure that you hit, you achieve 5% of your sales targets this month 1, 10% in month 2, 40% in month 3. So you sort of have it tiered. So it makes it achievable, and you're not setting up an employee to fail, which can be looked unfavorably when it goes to tribunal situations. Number 6, you include an available resources list. So what resources do you as an employer have to help the employee manage their performance better? Is it training? Can you do in-house training? Always look at in-house training first as an option before you look at external training. There's this habit of trying to put people on courses and think that the problem is going to be fixed. But quite often, in-house training is much more useful because it's more tailored to your company, it's more tailored to your culture in your company, the way that you believe that success can be achieved. So perhaps testimonials from current successful employees and tips from successful employees, and having that in-house training really works. Provide a timeline for performance improvement goals. We've said 3 to 6 months, but again, perhaps you should have a meeting every 2 weeks to make sure that certain objectives are constantly being hit on the performance improvement plan itself. Mention the metric used to measure progress. I talked about percentages, for example, for sales, but is it, for example, making sure that you respond to 10 emails a day, or is it responding to 50 emails a day? Having that tangible objective and goal and putting a numerical value to it can also really help employees kind of gauge and understand things better. We talked about reviewing the performance plan regularly. I think that should be done at least every two weeks, just to give the employee a chance to know where they're going wrong, and to give them a chance to improve over the months. Getting employee feedback, again, it's an area where people do fall because they have the performance improvement plan in place, they just don't get any feedback, and the employee just feels disheartened and wants to leave, resign or retire, possibly give up, but we don't want to do that, of course. Follow up and document. If it's successful, then obviously I would still say keep the performance improvement plan on file, not for too long, but between 3 to 6 months and then take it off their file. But you've got a track record there. If it does happen again, you can revisit it. And of course, it's important to draw a conclusion at the end of the performance improvement plan, where you can make a decision on what you want to do next. Is it going to be promotion, possibly because they've improved so much, or is it going to be demotion? Are you going to look at demoting the employee? And if you do, then obviously you've got to be careful of the legal considerations around demotion. I'm going to hand you to the wonderful Lucy now, who's going to talk us and guide us through recruiting for the HR function. She's very experienced, and I'm quite excited to hear what she has to say.
Thank you, Kishan. I'm really excited to be here. I thought I'd do something a little bit different. Many HR professionals, business owners and things like that, we're used to recruiting. We recruit across the business. We know how our line managers want. We know how to get the best out of the candidates for them. And then when it comes to our own function, we tend to freeze a little, and we're not too sure, of the best way forward, or we become very precious about what it is that we need for our function. So I wanted to sort of talk about some of the consideration points around recruiting for potentially your own team or potentially the HR function within your business, which is quite crucial, and what sort of things we should consider around that. So this is sort of assuming that you've already assessed your requirement and decided what it is that you need. Yeah. So we're now looking at the job description, and I'll sort of take you forward from there. So why are you recruiting? That's the main question I would ask in the first instance. And as we all know, that can be for a variety of different reasons. But to me, there are three main considerations when looking at the role itself. Firstly, the purpose of the role. Now, is the purpose of the role to backfill perhaps a successful colleague who has recently exited the organisation for whatever reason? Is it a newly created role? Perhaps your organisation is growing and you need an extra hand on deck to help you with some key operational objectives. Or, perhaps this is the first HR role in the business. Perhaps you've grown your small business to the size where you're thinking, actually, yes, we do need some HR support to make sure we're really ticking the boxes and getting the most out of our people. Once you sort of decide that, that will help you better determine the type of person you're looking for, because of course it takes somebody quite different to come in and establish a HR function to somebody who can effortlessly step into an existing role and really get the best out of it. The next thing I'd look at would be context. Now, the reason I speak about context, and you'll hear me speak about that over the next few slides as well, is it really can make a difference to the type of person that you need and the way you bring them into the business. Now, when I say context, that can mean a variety of things, but mainly thinking back to the purpose of the role. Under what circumstances will this person be joining? Now, again, it's quite different to have somebody join a role that's previously been made available because somebody has exited the business. Now, what circumstances have they exited is an excellent consideration point. We would like to think that everybody sort of, leaves an organisation where it's absolutely the right time for them and it's, all smiling when they're leaving, but it's not always the case. Also, what have they left behind? Is there, a lot of work still to do? Is there a lot of improvements to be made? Or is it a case of just picking things up where the last person left off? And also the wider context. What's the organisation's view of HR? Now, some larger corporate businesses, as you would know, Kishan, have a fantastic view of HR. And, they want these people in place so that they can make the changes that are needed to drive the business forward. Smaller businesses, it can be a bit more challenging. Sure. I'm sure a lot of HR professionals on this webinar at the moment will have experienced resistance. It's part and parcel of the job, really. So that's another key contextual factor to consider. And finally, one would say most importantly, the team. What are the team looking for? How receptive are they to new people joining the organisation and, slotting it, and how easy is that transition going to be for a new person?
It can be quite daunting sometimes, couldn't it?
Yeah, absolutely.
Yeah.
And I think with HR, there's no downtime. So people are often quite apprehensive about someone stepping into their role rather than, you know, slotting in as you might in a more operational function. So it's always definitely an important consideration is the team, to make sure that they're happy with whoever it is that's going into the role.
Yeah, of course.
So once you've sort of thought about that, you can start applying it to the role itself. And that's when you can start assessing the requirements for the person coming into the role. So the most obvious one is, what skills do you need? Now, HR people are probably used to sitting down with managers and helping them pick out the skills they need, but I'm thinking a bit broader. So firstly, of course, you will have the technical aspects. What environment are they coming into? Is it one of change? Do they need this sort of in-depth TUPE knowledge? Do they need any industry-specific knowledge? Are they going to be an ER specialist? Are they going to be a reward specialist? What technical skills will they need to underpin those roles successfully? So that's, you know, the most obvious one you'd expect to see, but absolutely important.
It can be overlooked sometimes, couldn't it?
Oh, of course, And I think in HR, it's such a broad profession that it sometimes can be quite easy to assume that people have this base of knowledge, but actually, what is it you need them to do? If they're a business partner, but the main bulk of their role is change, then they need that knowledge, they need that exposure and that skill. But if they're a generalist who are going to be covering the full remit, then that more grounded, even exposure will be more valuable.
Yeah, definitely.
The second under skills requirement would be the customer group. Now, it might sound a little unusual to include that here, but it really depends on the business. Again, customers might be more receptive than others. So in your sort of larger corporate firms, and I'm generalising here because it can be any firm, may be very receptive to HR. It may be a professional firm, you know, such as Fusion or Absolute, where, you know, you're dealing with professionals who are quite happy to lean on HR. But you, again, by the same token, you may be in a completely different environment where you're dealing with, you know, high volumes of staff, shift workers, you know, people sort of the sort of blue collar area, and it might be very different skills that you bring to the table for each role. When you're dealing with you know, very qualified and professional people, you need to be quite agile. You need to know that, speak to them on a level that they appreciate, that they understand. You know, be prepared for sort of anything that they may have for you. And you know, on the other hand, if you may be in an organisation with a high volume of ER casework, there might be some challenging customers. What sort of person do you need to best respond to these customer groups and get the most out of them? And of course, looking back at the team, what knowledge and skills do you have in the team? If you've already got a change expert, do you need another one? Would you be better off looking for someone who, you know, does focus on reward or recruitment or something completely different? So really kind of recognising that gap there and making sure that the person who's coming in is adding the most value and hopefully bridging that gap as much as possible.
Definitely.
The next one is cultural fit. Now, I think everybody will say to you, Kishan, that this goes without saying. And everybody would like to think that it does, but it's sometimes much more difficult to assess than you would initially think. So with that in mind, I would suggest thinking about the organisation itself. Not only you know, the type of business it is, the products or services it provides, and the customers, but also the brand. Does this person, you know, proactively represent the brand? Do they, you know, do they fit well into the mission? Do they hold the same values? Are they going to fit into the wider business in that way? There's also the team again, and I will keep going on about the team because it is so important. But HR is a very high pressured profession. You know, everybody's sort of working really hard to make sure things get done and they get done well, and to deadline. So it's often can be a bit of a pressure cooker if there are personality clashes within the team.
Yeah, of course.
So culturally, are they going to fit in the team? You know, if it's a team of people who like to go out every Thursday to the pub, potentially might not suit everybody, you know, and by the same turn, if it's a quiet team who, you know, sort of socialise during the working day, but beyond that aren't really involved, somebody who wants to, you know, start a society or might not fit. So it's just really being mindful of that.
Sure. And I guess it's quite hard, but the cultural fit is an important one, but I guess it's quite hard sometimes to vet that at a really early stage.
Absolutely.
Because, you know, how well can you know someone at interview? You only know someone when they've joined, you know, maybe 3 or 4 months down the line. That's when you really get a good understanding of it.
Yeah, of course. And I think, again, with HR professionals in particular, they are so familiar with the process that it's very easy to put your best foot forward. And who wouldn't at an interview? I know I certainly would. It would be my advice to all of my candidates.
Yeah, of course.
But yeah, you're absolutely right. It's quite challenging to assess that at that sort of initial meeting, which is why I think you should think about the team and potentially getting them involved when you can, getting some customers involved, and you know, sort of getting under the skin of the person. And I think from the business's perspective, for me as well, be honest. You know, if you're not a sociable team, tell the candidate you're not a sociable team, because they're going to find out, and actually they might not be the right person for you.
No, I agree.
But there will be someone that is, and there will be a right organisation for that person.
Yeah, definitely.
I think the next bit with the culture is the customers. Again, who's going to fit in with these customers? And I think, you know, we covered that on the previous slide, but it's always important to consider who they're going to be dealing with. Now, if they're sort of junior, entry level, and their main customers are going to be the rest of the HR team, then, you know, happy days, you sort of skipped a consideration point. But if they are sort of business partner, manager, director level, then of course, you need to consider how they're going to fit in with the wider senior management team and the business overall. And then finally, their employment background. Now, this one, Kishan, leaves recruiters sometimes scratching their head, because in some instances, it's absolutely essential that somebody has that employment background knowledge, that they've worked in a similar industry, they know the lingo, they know all of the considerations that are needed. So one example might be in healthcare. There are obviously some quite stringent recruitment practices that need to go on. So having someone who's already experienced that will be beneficial. But then there are other industries where I would always say, ask yourself, is it really essential they've worked in an identical organisation before? The answer might be yes, but is there a similar industry or a similar breadth of experience they could have got elsewhere that will make them the perfect candidate for your job? And you're not just dismissing these people because of, you know, where they've come from, if you like, where they've previously worked. So that's why I would say always ask, is there any industry specific skills or attributes that you need that cannot be gained through any other channel? And if the answer is yes, then by all means, that's what you need and you run with that. But if the answer is no, then I would certainly broaden the search pool. And as a recruiter, if one of my clients was struggling to find somebody, that would be my first bit of feedback. You know, is this essential to the role in your business? And if not, let's regroup and think where else we may be able to find someone. Now, back to the cultural fit. And I know you mentioned earlier, Kishan, how do you assess the cultural fit? Now, again, it's not a black and white area, it's very subjective. And you know, it can depend on the day of the week. You know, some people are terrible on Mondays, but fantastic the rest of the week. So, you know, is it fair if they've done a first thing Monday morning interview to decide whether they're right for the business? So what I would say is, by this point, you should have assessed the required attributes, but think about what this looks like in practice. Now, cultural fit goes beyond, you know, whether or not they're likable, whether or not they're a good representation of the brand, but actually their work ethic, how they're going to get things done. So it's not the what they're doing, it's the how, and does that fit in with the strategy of the organisation, the values of the organisation, and is it going to get things off the ground? So when you're assessing the cultural fit, I would definitely recommend you look at the role again and pick out anything that may tell you the type of person you need culturally to fit in. So again, if it's a a manufacturing firm that experiences high volume ER casework, potentially you'd be looking at somebody who's highly organised and, is quite resilient because they may be having, quite a few difficult conversations. So really sort of examine the duties of the role, the context, and what sort of attributes you would need to fit in with that culture. And again, the team. Now, we've spoken about the team a lot, but I really feel it's easy to get it wrong, and it can be quite devastating to a well-oiled team. Now, if the team don't quite gel with this person's way of working, so aside from the socialising and are they a likeable character, aside from that, if the way of working is off, then it can throw the whole team out of kilter. If you have a business partner who likes to zone in on their work and doesn't really get other members of the team involved, but actually you're quite a collaborative team, it's only going to cause problems.
I like the idea of sort of getting the team more involved in the sort of the pre-application process, or during the application process. I think that's quite a good touch. Perhaps it's a good idea to have more sort of apprentice style interviews, if you like, so there's a bit more sort of a longer process, because ultimately you want to make sure you choose the right person, because it's an investment in time and an investment financially, but also in time. And the only way you can really do that is if you invest a bit more time before you hire them.
Yeah, absolutely. And I think it's a fine balance, because again, HR people are very used to interviewing. They're familiar with the process. This is both sides, so the candidates and the organisation who is looking to appoint. So it can be quite hard to suss people out, if you like, get the most out of them, whilst also making that evaluation on the culture. It's can you ever really 100% know? I feel like there's always an element of risk when you hire someone new. But you can absolutely make sure you're completely prepared for any nasty surprises that may be on the horizon. And of course, meet the candidates.
Of course.
I think the best way to assess culturally how someone will fit in is to get them in front of you. It's all very well having a perfect CV, but you could meet them and they could be, the completely wrong person for the job. In fact, I've had it with, clients of mine who have seen a CV and thought, that's fantastic. That's who we're looking for. Don't send me anyone else. I'm really confident. And, the person could be fantastically skilled and, really personable, but they're just not right for them. And that's why I meet them. It's time consuming, but a recruiter who, sort of is worth their salt and does their homework will be able to give you a lot of insight before the stage of meeting them, and hopefully by this stage you won't have any candidates that are completely unsuitable. It will be more about fitting them in the right box.
I'm surprised that some companies will actually take people on without interviewing them or meeting them.
Oh, that's
so
very rare.
Often.
But I think a lot of our clients, a lot of my clients in the past, it's very easy. And I've been on the other end when I was working in HR. You see the CV, and it's so easy to get your hopes up and think, do you know, this is exactly what I'm looking for. I mean, it's like it was written for the job description, and then you get them in front of you, and actually they're just not quite right. And it doesn't mean they're not fantastic candidates, but
not right fit.
Yes, absolutely. Now, once you've sort of done all your assessments and you're sort of figuring out, I just wanted to do a quick piece on managing the process. Now, I don't want to, rehash old ground. I think most people in HR will know a standard process. I think a lot of business owners will know a standard process, and I'm sure you're familiar with what it could potentially look like. I just wanted to touch on a few things, and again, how we can get the team involved and make sure we're making smart choices. So I think the first thing to consider is, what do you actually need to assess? It's all very well having pre-written competency questions, but if they're not telling you what you need to know, then the value is gone, and can be quite off-putting for a candidate. If you're asking them, a junior about complex ER cases or their knowledge of employment law, is it necessary, when actually you need someone who's an absolute whiz with HR systems and highly organised? So I think pick out the things you need to know, and then decide how you're going to test them.
Okay.
The second part would be, who is involved at each stage? And I know we spoke about the team being involved. It's difficult in HR because it's common that everybody can see everybody's information. Now, depending on the dynamics of the team, that can be quite tricky. At what point do you want, one HR manager to see a HR manager candidate's CV, if they're going to be working in very similar roles? My advice would be to sort of step back and think about being as open as you can without causing any sort of frustrations or upsets there. I don't think it's commonplace that, people will fly off the handle and be upset, but it's always worth sort of keeping an eye on how things grow. You've also got to remember, in larger teams, there's always politics at play, no matter how much we try and mitigate those. So who is the most appropriate person to be involved? So, for example, if this is a senior HR manager position, do you really want the HR advisor, who may be reporting into them, seeing their credentials? It may not be considered appropriate. So I would consider this at sort of every stage. So CV screen, I wouldn't share a HR manager's CV with one of their direct reports, for example. That's a personal choice. But I may get the HR assistant involved at the face-to-face screening stage. It depends. It's a balance. Then, of course, telephone assessments. Everybody has been through one of those, either on either sort of end of the phone. But again, it's a good way to gauge people before getting them in. I think when you get to a senior level, it can take quite a lot of time to get a lot out of an interview. So actually doing a quick telephone screening, making sure they understand the role, making sure that you've clarified any questions before getting them in for that face-to-face can actually save you a lot of time.
And it's a good way of sorting, isn't it?
Absolutely. And I think, a good recruiter will always do their best to relay the details of the role as perfectly as they can. But there's always things that can slip through the cracks. For example, if there is any big change initiatives going on, you may not wish to share that with a third party as a hiring manager in HR, but you may wish to gauge a candidate's reaction to it. So it's always worth doing if you can. And then, of course, face-to-face stages. Now, how many of those would you say are optimum, Kishan? How many face-to-face stages would you expect?
Oh, I expect at least 2, 3.
2 or 3?
Yeah.
See, that's very interesting, because I would say 2. But then I have some clients who do 1. I have others who do 5. I think one of my clients earlier in the year, they had quite a thorough process, and it was 4 stages. So it was a telephone and then 3 face-to-face. And again, it depends on the role. So if you're struggling to know which stages to focus on or how many to have, I would definitely look back at the role and remember that this is your candidate's time too. If you've brought them in for 5 interviews, each an hour long, and there's still a chance that they're not going to get the job, is it worth your time and their time to go through that and try and condense it and get what you can out of them in sort of
I guess the disadvantage of having seen that person too many times is sometimes you get sort of confused, because you might have like them like 2 times and maybe not like them the last time I met.
Of course.
So I guess that's where it becomes difficult.
And I think if you're seeing some of the 5 stages, naturally, you'd hope they're seeing quite a few different people. And at what point does that become manageable with all those sorts of views coming into play? I think also thinking from the employer branding side and the candidate experience, if there seems no purpose to having all these stages face to face, then that can be quite frustrating. Now, if it's quite clear what's going on, there's a clear path. So we've done our CV screen, our telephone assessment, and we are, let's say, 3 face-to-face stages. One of which you'll meet the line manager, one you'll meet the customer, and the third you'll meet the team. Then that's quite clear for candidates that they understand the purpose. But if you're sort of just not quite sure and calling up the recruiter and getting them in every week for however long, that can actually create quite a negative impression of the company, which is, keen to avoid.
Yeah, sure.
And then, of course, technical assessments. Now, for a senior role, so a senior business partner, director, even a HR manager, I would expect to see some sort of assessment in there.
Of course.
It's not essential. It depends on the role. If it's a pure generalist HR manager role in a small startup organisation, it may not be necessary. You may not have the in-house skills to effectively assess that anyway. So think carefully about what you're testing and why. But I would expect to see some form of assessment, be that a presentation, be that, I've seen also paper trails, anything like that, policy amendments, just to sort of make sure they are where you would expect them to be. I think in any profession, you can rack up years in it, just sort of by doing not very much, but make sure you're sort of hitting the note with the technical assessment. For junior roles, it's I don't think it's necessary. Perhaps if it's a grad scheme or an apprenticeship, then absolutely, to sort of cream off those fantastic candidates. But if it's a HR assistant, is it necessary that they know these details about the HR profession at that level in their career? That's up to the client, but I would question it.
Yeah, sure. Interesting.
Ooh, I've just skipped.
You just skipped one. That's fine.
So really, I think the purpose of the process and going over the process is, trying to challenge people to think about how they do things. Do you want to put people through these elongated processes, or do you actually just want to find the right person in the most efficient way possible? And who's involved at each stage, as we discussed, will depend on what the role is and what the team's like. It may be completely inappropriate, but I think if you've got a good recruiter and you're working with someone who knows their candidates well and knows your business well, then they can sort of help you through that process and finding the right way forward with the candidates. And I would never send you, Kishan, a candidate that I hadn't already met and made sure they were up to your standards anyway. But you may wish to, you may be taking a direct approach. You may be advertising online and screening your candidates, and I would apply the same approach. And even for other areas of the business, I'd challenge your line managers to do the same, just to make sure you're getting the most bang for your bucks.
Definitely.
When recruiting.
Of course, thank you so much, Lucy. That's certainly opened my mind in terms of how different aspects of recruitment and different things to think about, because there's a lot there that I didn't know before, which certainly I think hopefully it has helped our viewers out there. Of course, if you've got any questions, then please do approach Lucy, Absolute HR. So just a little bit about our services. In terms of employment law, we provide, as part of the Learning HR scheme, we provide an employment law advice line, a subscription service, in-house employment law training, specialist employment law tribunal insurance, which we've offered to a lot of our clients. We draft your employment contract, staff handbook, policies and procedures, your GDPR privacy notices, and your privacy policies. We've done a lot recently in terms of helping people become GDPR compliant. So get in touch with us if you're interested. I mean, we offer we offer an in-house legal and HR team from only as little as £150 plus VAT per month, where you get unlimited legal advice from us, unlimited HR advice, a full legal and HR audit of your business, and 25% of all other fees. So yeah, get in touch with us if you want to know more about our employment law advice line. So questions and answers. You may have some questions for myself in terms of the topics I've covered, and you may very well have some questions from Lucy at Absolute HR. And if you do, then please feel free to email me at kishan@fusionlaw.co.uk. We thank all of you for listening to us today, and we hope you can join us for episode 2, which will be on social media and the impact of social media on employees and HR. So watch this space, and thank you for staying tuned. Bye-bye.
Yes.